Be ready. 5 seconds. Thank you, sir, for affording me the opportunity to speak on this important issue, High Court and Supreme Court Judges' Salaries and Conditions of Service Amendment Bill 2021. In the bill, a very small clarification is there that on the completion of a particular year of age, a judge is entitled for the pension. Sir, I rise to support this bill. I would also like to say that as far as the salary part is concerned and pension part is concerned, this Honorable August House always supports it. So far as the remuneration part of the judges is concerned, it may be High Court, or it may be Supreme Court, or it may be subordinate court. It is far less compared to the other countries. That is the reason that even after superannuation, some get employment elsewhere. Now, regarding the question of conditions of service, as far as the conditions of service with respect to the appointment of the judges are concerned, it is there in the Constitution of India itself. It is for the High Court and Supreme Court judges. But for the subordinate judiciary, it can be done by an act of the state legislature, or it can be provided under the rules framed by the High Court. So far as the conditions of service are concerned, the conditions of service of the judges of the Supreme Court are framed under Article 125 of the Constitution of India and under 221 of the Constitution of India for the High Court judges. The Parliament is competent to lay down the conditions of service of the High Court and Supreme Court judges. Apart from their appointment, other conditions of service can be laid down by the Parliament. Now, we talk about independence of judiciary and all these things. This part has been given by the Constitution to frame the conditions of service by the Parliament. So far as the appointment part is concerned, it is under Article 124. If we read the conditions of service, we can see so many conditions of service in the Act 1954 and 1958. I will come later on to the exact issue of independence of judiciary. When we consider about leave, even for leave, the condition of service is to be laid down by the law made by Parliament. Even for salaries and pensions, the conditions of service can be laid down by the law made by Parliament, and other conditions of service are also contemplated regarding perks, etc. Not only the salaries of the judges are protected, the tenure is also protected. So, we can say that the independence of judiciary is secured by the Constitution of India. When we come to the judicial reforms are not limited only for dealing with the filling up of vacancies and other issues. It is also related to the conditions of service of the judges. It is also related to the appointment of judges because the Constitution framers specifically provided under Article 124 that the judges of the Supreme Court shall be appointed by the President of India after consultation with the Chief Justice of India. In this connection, as far as the High Court judges are concerned, the High Court judges are appointed by the President of India under Article 217 after consultation with the Governor and the Chief Justice of the High Court. So, the consultation part is there. For 43 years, right from 1950 to 1993, this practice has been there. A large number of judges were appointed in the Supreme Court and High Courts. They were exceptional judges. They rendered quality judgments. Their judgments are referred everywhere. Even these days also, they are laying the basic principle of law. So we cannot say that the judges who were appointed before 1993 under Article 124 and 217 of the Constitution of India were lacking quality. Everybody knows what type of judges we are having after 1993. I am not saying that the judges are not good. They are equally rendering very good judgment. But we cannot say that when the executive involvement was there, the quality of judges was less than the quality of judges that we are having today. All the judges prior to 1993 were equally competent. Sir, the first judge's case was filed by Shri S.P. Gupta. In the judgment of this case, the word consultation appearing in Article 124 and 217 of the Constitution of India was defined that consultation means that no primacy can be given to the Chief Justice of India, and apart from this, it stated that consultation does not mean concurrence. That was the judgment in the first judge's case, which came in 1982, where it stated that consultation does not mean concurrence. So, the problem started from the second judge's case, 1993, because it amounted to rewriting of the Constitution by this judgment. Then, a reference was made by the President of India under Article 143 of the Constitution of India. If we see Article 143 of the Constitution of India, it provides for seeking the opinion of the Supreme Court. Now, the question is whether the opinion rendered by the Supreme Court is binding on the President. We have to consider this very seriously. Whenever the opinion of the Supreme Court is sought by the President of India while exercising the power under Article 143 of the Constitution of India, that opinion can be binding on the government, as it happened in the third judge's case in 1998. So, Article 143 of the Constitution of India provides the power to the President to consult the Supreme Court. It says, if at any time it appears to the President that a question of law or fact has arisen or is likely to arise, which is of such a nature and of such public importance that it is expedient to obtain the opinion of the Supreme Court upon it, he may refer the question to that court for consideration, and the court may, after such hearing as it thinks fit, report to the President its opinion thereon.